are listening to the Bell Post. Welcome to episode 42 of the Bell Post. On this week's episode, I've kind of entitled this episode "The Tale of Two Counties," where we compare and contrast the county of Coleman County, Alabama, with Harris County, Texas, and two different approaches to this federal litigation that was essentially filed by the same group. And today we're going to talk about a specific case called Schultz versus Alabama that went all the way from trial to the United States Supreme Court. And we have with us today our guest, Sheriff Matt Gentry, who ended up being the named sheriff in the petition for cert at the Supreme Court of the United States. Welcome to our show.
Yes, sir. Thank you for the invitation.
Well, in looking and doing a little research about you, you were born and bred in Coleman County.
Yes, sir. I was born here and pretty much lived here all my life.
Well, and you worked your way up all the way from high school, Good Hope High School, all the way through and going to the Marines and then coming back and starting at the sheriff's office.
I did. I always tell a story to the people I speak to. After graduating Good Hope, I went to the University of North Alabama to play football, and I love football, but I didn't like school, and I didn't know you had to be good to stay there at both. So I figured the Marine Corps would be easier than finishing college at that time.
My daughter just started college, my youngest, and she called us this weekend and said, "I don't think my high school prepared me for college." And I was like, I think that's pretty normal, sweetheart. I mean, there's always a transition to college. And, you worked your way up in the sheriff's department, all the way up. I mean, you graduate from the Alabama Police Academy in Tuscaloosa. What does that entail?
So, that's a 12-week academy. And actually, it's kind of funny. So I was in the Marine Corps Reserves out of Bessemer. I was with the 4th Battalion, 14th Marines, and kind of got to know some guys in law enforcement. And I started what I call at the old jail. That was before we were politically correct. We had things like the drunk tank, the hole, all them. But and it looked like Andy Griffin. It was the bars and all that. But so I started in the jail, and then I had been 21 about 2 weeks. I hadn't been 21 very long, so I was able to get hired on. And then I went to the academy. So the academy is a 12-week long academy, and it gives you your hours to be a certified law enforcement officer in Alabama. And so I went through the academy, graduated the academy, and then went to patrol. And then in 2004, I started working narcotics, and then I spent the next 11 years working narcotics. 2009, I took over the 2008, took over the drug task force. 2009, I had an opportunity to go to Quantico to the Drug Unit Commanders Academy. And in 2011, I kind of took a different path. I got on with the district attorney's office here, and was assigned down to DEA out of Birmingham. So I was working on the federal level, state and federal then, and then ran for office and got elected in 2014.
Well, talk to me just for a moment. I mean, tell me about being a Marine. What does being a Marine teach you? What skills did it teach you that you kind of have carried forward with you? Because I can look at you and go, I can see you being a Marine very easily.
Well, it's like anything in life. It's what you take out of it. But, it taught me a lot about discipline and honor, the things that we stand for, and never to back down. If you stand and do what's right, there should never be a time that you back down. And Marines always move forward. We never move backwards. We always move forward. And it taught me a lot about a brotherhood, which I'd been in, prior to that. I was actually an Eagle Scout and, went through school. But that bond that we had have in the Marine Corps still helps me today. If I'm flying somewhere or I'm going and I see somebody with an Eagle Globe and anchor on, then we have a bond in common. But it just teaches you a lot of life skills about not giving up. We always had a saying in the Marine Corps, the only time we'll quit fighting is when we die. So.
Wow. Probably one of the best compliments I ever got from somebody was somebody who was leery of me and didn't know me very well. And he said, Ken, I've been watching you, and I've decided that you really just want to do what's best for your industry. You don't have a private agenda. You're not trying to hurt somebody. You're just trying to do what's best for everyone. And I've carried that with me a lot. I mean, it just seemed like a small thing at the time, but it's really stuck with me because I mean, I really think that's true. I try to do what I think is best. But I see a lot of similarities in what the Marines teach you. Don't back down, do what you think is right, and everything will work out.
Yes, sir. That's right.
Well, what made you decide? I mean, I know you're married, you have two boys, and
Yeah.
I'm always want to highlight family. I was older when I got married, and I would say that I have loved every minute of being married. And God gave me two girls because He knows how competitive I was. And I am. If I had boys, I'd be the worst parent on the side of football sidelines. And so He gave me two girls. I couldn't do that at the back of the room at the dance recitals, but but I have great memories of being a dad of girls, and so. But you've got two boys, and so I'm sure they're very much competitive.
They are very competitive. So Susie and I, we've been together 23 years. Last week we were married 20 years. So we've been together a minute, but I have my son William that's 15 and my son Walker that will be 13 at the end of this month. And both boys are very competitive, very athletic as far as playing sports. Both play football. Walker plays baseball, and now they're both picked up golf.
Well,
And
I'm going to tell you, I'm a firm believer in keeping your kids busy because if you keep them busy, they can't get in trouble, or they get in trouble less. But I remember,
right.
I mean, I don't want to put you on the spot, but when my daughter was 13, we call that the cold winter because, she didn't want me to hug her one time. And then she turned 14 and then it was hot, cold, hot, cold, hot, cold. But I give her a hard time about that. She's my oldest. She's 24 now, but I love everything about being a parent.
It's great.
What made you decide to run for sheriff? Because I think you ran against the incumbent.
I did. The good Lord just laid it on my heart, and I knew February the 13th of 2013, I was supposed to run for the office of sheriff. I got up and I read my daily devotional, and the good Lord punched me in the mouth and said, "I want you to do this," and I did it, and we were blessed, and we ran against the incumbent and won.
Well, that was back in like 2014. You took office in 2015, and then just a very short time later, you're getting this litigation. And I saw somewhere where you referenced you were first sued in state court and then won, and then they went to federal court. Can you talk about that for just a minute?
So the day that we took office in 2015, the day I get home, I'm taking my boots off and I'm talking to my wife, and I get a call, and we're in a car chase and then a 7-hour standoff.
Oh,
The
wow.
first day that I took office. So we've been used to difficulties. But yeah, so I originally got sued in state court, and we had a habeas hearing uh with these guys and won the habeas hearing. Of course, one of them Schultz, sex offender, and then the other one was a drug trafficker, and had a habeas about them being in jail on bond. Now they were eligible for bond, they just couldn't make it. Both of them had extensive criminal histories. And so after we won our state habeas hearing, then that's when we received notification that they were going to try to sue us in federal court.
Well, in the habeas proceedings where they're in the middle of a criminal case and they haven't, have made bond, and so they file what we call a petition for writ of habeas corpus, asking for someone to overlook it, either the trial court or the court of appeals, to overlook it or review it and order their release. And so, I like to say, look, if you're in jail and you have an extensive criminal history, you're not in jail because you're poor. You're in jail because you have a criminal history.
That's correct.
Okay, so you won the habeas corpus, and then
Yes.
you get sued in federal court. Now, I know counties get sued in federal court all the time, and I know we're going to talk about a little comparison with the O'Donnell case out of Harris County, and the O'Donnell case was kind of pending for a year before it was real clear that that case was going in a really bad direction. What about this Schultz versus Alabama case? How soon was it that you realized, oh, this is a dangerous case?
Well, so originally with the Schultz case, it wasn't that bad. I mean, we kind of knew the facts and this and that, and we go to federal court, and they're just starting the process. My attorneys had already told me that the original two complainants, which was Melvin Hastings
Sure.
and Tommy Drake, didn't even file the original complaint correctly in federal court. So I was actually at the sheriff's conference, and I was sitting there, and I was actually talking to our attorney, Randy McNeil, and he said, "Hey, the Southern Poverty Law Center is asking about a guy named Bradley Hester that he's in jail, he's got a spider bite, and he's not receiving medical treatment," which was incorrect information. So I'm sitting there with him. I called the jail, and they send the information where he's received treatment. He was in there on a $1,000 property bond
Sure.
in jail. And so we had everything sent to him right then. Our jail here, and that was kind of the first time that I thought, well, something's weird now because there's two local attorneys, and now the Southern Poverty Law Center is asking about another inmate.
From what I can tell, this case was pending a while, similar to Harris County, and then this Hester filed a motion to intervene in 2017, but then
Yeah.
filed a complaint or intervener complaint on March the 9th, 2018, and then filed a preliminary injunction with this intervener 3 days later. And then you had a preliminary injunction hearing. I know the preliminary injunction, the ruling was sometime later, but there was this point in time where y'all decided that y'all needed to tweak or make changes to the bail system that y'all were using at the time that you got filed suit. How did that discussion come about, and how did that turn into we need to make changes?
So with the original lawsuit, it was, of course, they filed a lawsuit against me. The four judges, so our two circuit judges, our two district judges, and the circuit clerk. Now, I was represented by Randy McNeil at the time it was Webb and Ely, and then Jamie Kidd was the attorney assigned to my case. The other judicial defendants, they were represented by the Attorney General's office.
Yes.
So they were represent. So their attorney made reference that, hey, look, because of the way the Alabama bail schedule, it's a range. It's not a set amount. It's a range. And just to show that we want to cooperate and at least work with the the federal court, let's see if we can come up with a compromise. So their attorneys were saying, look, let's set a set schedule. So where, normally, let's say like trafficking and meth would be a range from 5,000 to 1.5 million. They wanted to come up with a set amount and then have the presiding circuit judge set that amount to come down to the jail, because the presiding judge is the one that actually sets the bail schedule that comes to the jail for us to set bonds at.
Yes, sir.
And that was kind of the consensus, to try to work with the system, not against it, but to work with it to show, hey, we want to do what's right.
Well, I found that very interesting because, if we go back in time, about the time y'all were being sued, there were groups that were approaching counties saying, hey, if you don't want to be sued, you need to adopt what we would refer to today as a risk assessment. And, I think Dallas County, which is the Daves case versus Dallas County, which is pending at the U.S. Supreme Court currently, they did that. And, they ended up wasting a lot of money because then they had to redo everything once again. And so I kind of thought, this was a great idea. It turned out to be very important in the case. And, the point is, who do you listen to when they're suggesting to make these changes? And so in this situation, the suggestions were coming from the Attorney General's office from the state of Alabama.
Yes, sir. And we all met and talked about the amounts, that would be reasonable for any person under those charges.
Well, and the other changes that I saw in the updated bond order was that, you have the scheduled amounts, and they're not arranged, they're a scheduled amount. And then if you, the sheriff or your office, thinks that's not enough because of a criminal history, y'all can request a hearing. And then if someone has a bail scheduled amount set, but they can't bond out, they're treated the same way. They have a hearing with the judge under the bail order. And I thought those were both under the law that has developed over this same time period. I thought both of those things were spot on and great decisions of how to change and make your order better. If you want to compare that to what Harris County did, Harris County just got rid of their bail schedule entirely and then started requiring individual magistration for everyone.
Wow.
And, that just created a lot of chaos when you're arresting on average 5,000 people a week. I mean, it
Yeah.
makes it almost untenable. I mean, talk about what is the benefits of having a bail schedule?
Well, so in Alabama, we have 67 counties. And I remember for years, what we did in Coleman may not be the same as in
Sure.
Morgan or Blount or another county that joins us. I always remember we always had a reputation for if you got arrested for trafficking, your bond was set at $1 million. Where other counties you would get arrested for trafficking or class A felonies and your bond may be $5,000. And it was actually a little bit when you talk to criminals, it was a little bit of a deterrent that would say, I don't want to get caught there because the bond there is $1 million where I can go here and do bad things and it's only 5,000. And that always stuck out with me over the years being a young deputy growing up, getting the perspective from the criminals.
So you're going to a hearing on a preliminary injunction, which was days after really this new system went into effect. It seems
Yes, sir.
like the attorneys really agreed to a stipulated set of facts. There really wasn't much evidence. And there was essentially, according to the Court of Appeals, there was no evidence offered concerning the new system. And then I mean, did you have some idea at that point that you're faced with you may get faced with a preliminary injunction that's just going to cut your knees off?
Well, not then. So they came down and myself and one of our district judges were called in to testify to the bail system. The unique thing is the federal system is completely different than the state system.
Sure.
So I was able to go in and testify on the differences because I'd worked so much in the federal system that I knew it and I knew the state system. But the thing that struck me is when we went into the courtroom and they came in and they said this is about the taxation of the poor. And then I knew then I said this may go downhill.
Yeah.
Um, and so they kept me on the stand for over 8 hours,
Wow.
over 2 days and I testified to the two systems, how federal court works, how state court works, everything from truth in sentencing to the number of arrests that we make, because we're like other counties. I mean, we're making thousands of felony arrests a year and those kind of things. And even how families use the bail system to try to get their loved ones help,
Sure.
and they've used that over the years.
So the preliminary injunction is handed down, and I mean,
Yes.
it is substantial. I mean, it's like essentially. I mean, how did you interpret the preliminary injunction?
Judicial defendants have absolute immunity. So
Yes.
it didn't really affect them at all because they have absolute immunity. I'm the only one that did not have absolute immunity. So that's why the judges could make me do something that they couldn't make judicial defendants do. And so when the injunction came down, I knew it was going to be turmoil for our entire judicial system in Coleman. So we met office wide with all law enforcement in Coleman and talked verbatim to what we had to do in the system under the injunction. And we did that, of course, working through our attorneys, Jamie Kidd, and then the judicial defendants also.
Well, it looked like under the preliminary injunction, your hands were almost completely tied. You were required to release people essentially, I don't know how you want to refer to it, without bail, without accountability.
Correct. Correct. Yeah. And that was the thing that was hard for us because it didn't matter what you got arrested for. Essentially, you're going to come in, sign your own bond, and leave.
And that was for
And that,
misdemeanors or felonies across the board.
correct. Correct.
This is interesting because, in the O'Donnell case, they started out with misdemeanors. And then in the Daves case, they tried to extend that ruling to felonies. And I guess in the Calhoun case, this city of Calhoun case, that was really just misdemeanors as well. So y'all were the
Sure.
first case that came out where they were applying this across the board, just let them out on felonies and misdemeanors. And y'all lived under it for 4 or 5 years.
5 years. 5 years.
And when we say
Well,
you lived under it until the Court of Appeals reversed, but talk about that time period of when y'all lived under it? What was the impact on the criminal justice system?
Well, it was such an impact for us. We didn't see it in the first month or so, but by the first year and a half, we were seeing criminals that are not afraid to go to jail. And actually, we were having people that had been arrested years and years ago that were clean, running rehabs, running treatment centers, calling saying, "Hey, this system is killing people because they're getting multiple, I'm talking about multiple felonies a year now, or even within months or weeks. So they're getting arrested for one felony, getting arrested for another one. They're bonding in, bonding out. And there's no way to hold them to even try to help the ones that need help. And we were seeing a system that not only that, where people were getting hurt and dying, but also a system where our FTAs, our failure to appears in court, were rising up 60-70% because nobody cared, because even when the FTAs were coming down, they were unsecured bonds, and
Well,
it was just
people cared, but under the preliminary injunction, your all of your hands were tied. You couldn't do anything about it.
that was the frustration for us, was that we know this is hurting our community. I mean, this was not good for the citizens of our county, communities, or even a lot of the bad guys.
Well, I think that's what gets lost. And, I have, a personal story where I have a sister who had a car accident in '89. I remember it because that's the year I graduated from law school. And she started a 30-year drug addiction to painkillers. I mean, she broke every bone in her face. I mean, she
Wow.
just suffered from pain the rest of her life. And, back then, families didn't have a lot of money. Your drug rehab was the jail. I mean, you get them straightened out in jail and then figure out what to do with them. When you're forced release, I mean, what these people that are in these treatment programs are telling you, that's exactly what the poor people are seeing. You're taking away that option from poor families in our country under these preliminary injunctions because they can't get their loved ones straightened out.
No, and I've faced something similar. So my sister was an addict for 20 years. Knock on wood, and Lord willing, she's been clean 5 years now. And she actually works for a group that helps with treatment centers and stuff. But you take Hester. We had known Bradley Hester for years. He had been arrested multiple felonies. The misdemeanor that he was in our jail on was essentially, it's $1,000 bond. I mean, pretty much anybody can come sign his bond, but his family had refused because he had been part of the system so long.
Yeah, I mean that's a good point. I mean, I tell a story of the person who goes through the criminal justice system from first time offender to career criminal. The first time offender, they don't get kept in jail, but as they
No.
get arrested more and more, the first group that they walks away from is their friends, and their family is still sticking with them, but they can screw their family. They can hurt their family enough times that the family is out. They're done. And those are the people that need to stay in jail because those are the career criminals. And that's been impacted by this very short-sighted preliminary injunction. I mean, what we're doing is we're saying the jails can't hold anyone pre-conviction.
That's right.
And that's ludicrous.
It is, and that was one of the points that even when I was testifying, I brought up, just like you discussed, that for a lot of families, this is that time period that they need to get their loved ones clean and find a treatment facility for them to go to with working with us to try to help their loved ones get better.
Well, the other thing I want to highlight is you were mentioning that FTAs, failures to appear, skyrocketed, went up 70% or more. And, that's been seen consistently now across the country. In California, they use a similar release mechanism for misdemeanors. They have an 80% failure to appear rate. Harris County, they're still living under a consent decree, which is the preliminary injunction, but they did it by settlement. And according to HarrisCountyCourtWatch.com, reviewing 2 years of docket, their average failure, or 2 years of data, their average failure to appear is over 80%. I mean, a 70%, an 80% failure to appear rate is devastating to the criminal justice system, because all those cases get put on hold and you have to wait for them to come back to the system.
Well, and that was something that we faced. It went from a system where we were, we average, let's say, 20 arrests a day here. We're not a huge county. We're about 100,000 citizens, but we're averaging, let's say, 20 arrests a day. Well, we were seeing 30, 40, and then not only that, but our failure to appears were coming down by hundreds. Not 50 after a court proceeding. We were coming down 100, 200. So then that puts an
When you
extra
say coming
workload
down,
on.
you mean that's how many
Um,
failure to appears you have.
yes, on just one court docket.
Mm.
So those warrants will come down to us. So that means our records clerks were, normally doing 50 after a court proceeding. Now they're doing 100 to 200 warrants. That means that the circuit clerk's office is working that much harder, and these warrants were coming down, even though they were failure to appears. The defendants still could sign their own unsecured bond,
Mm.
so they were getting arrested for a failure to appear. So there was no reason for them to even come to court. They would just laugh and say, "We're going to come in, sign our own bond, and then we're not going to show back up anyway."
Well, and
So
what are the things I've learned through this is that the career criminals, organized crime, and gangs are the ones that have really learned how to make a killing out of this type of criminal justice system. If you can't hold anybody accountable, they're going to step in and make a lot of money.
they will, and that's one of the things. Let's say just drug dealers. So people selling drugs, they knew that, hey, we can sell all the drugs we want because they're not going to hold us. So whether we get caught with a pound of meth, or even now what we see with heroin and fentanyl,
Mm-hmm.
they're not even going to hold us. So that means we get caught for trafficking in heroin or trafficking in fentanyl. That means we get right back out and we go continue to sell more and more and more, which again, the overdoses were going up,
Yeah.
the deaths were going up because of that. So, those are the things that we were dealing with.
Well, we've had, I would say 4 different cases now that have gone through the system, all brought by this same plaintiff's firm. I would say, activist group. And Walker versus City of Calhoun, we've already mentioned, and then
Mhm.
your case, Schultz versus Alabama, and then the O'Donnell versus Harris County case, and now currently the Daves versus Dallas County case. Daves is pending at the Supreme Court and has, they're going to decide on the petition for cert next month. All of these cases are pushing this agenda that we have to just release people. And you lived under that preliminary injunction for 5 years. Talk about the day that the Supreme Court, or the 11th Circuit Court of Appeals, issued its opinion and reversed the trial court.
For us, that was a win. And I had this question presented to me. They said, wouldn't it have been just easier to agree and just move on? Well, no. I mean, that's not easier. If we had agreed 3 years prior and just say that, you know what, all bad guys can come in, sign their own bond, and leave, then think about what our community would be facing today.
Mm-hmm.
And that's what I told them. I said, number one, if you do what is right, you fear no one. And there's no way, as the sheriff of this county, that I could have ever backed down from protecting our citizens, and even the ones that get arrested a lot of times. That was one of the things I talked about in federal court was, I know mamas and daddies here. When people get arrested, I'm talking to mamas and daddies and brothers and sisters. So it would not even do them justice for us to back down and agree to a system that is just not right. And and it was a win for us. It was kind of like a breath of fresh air. We had dealt with this for so long. It was like, okay, we can finally breathe again.
Well, in the Harris County litigation, the local press was pushing for settlement. The local officials were pushing for settlement. The plaintiffs were pushing for settlement. I mean, did y'all ever feel pressure to settle in this case?
There was some talk, and Jamie Kidd, who did an amazing job on my side, said, "Hey, they're wanting to settle and do." She
Mhm,
did not want to settle. I will say this: our attorneys never wanted to settle,
mhm.
and I told her, I said, "We'll fight to the end. We will not have a case in Coleman that sets precedents all across. I mean, this not would not only affect Coleman, it would affect the entire state of Alabama." And I cannot imagine being the one that made a decision that would have a negative impact over the entire state.
Talk about the cost. Like in Harris County, they spent $8 million on attorney's fees and were winning. The first case to go to the Court of Appeals on a preliminary injunction was reversed. They came back down. The trial court entered a second preliminary injunction. It went up, and the Court of Appeals stayed it, saying that they believed the judges would win again. But before anything else happened, there was election, and the judges all got replaced by people promising to settle. And so then they settled, gave the plaintiffs everything they wanted, and spent $100 million implementing the settlement. Now everybody just forgets. Oh, everybody was giving them hell for spending $8 million on attorney's fees. How expensive was it to stand up to these people and say, we're not going to give in?
Well, it's anytime you have a legal battle, it's expensive. We spent several $100,000 in legal fees just at the sheriff's office. That
Mhm.
doesn't count what the judicial defendants spent. So, if you added we were probably over a million or so in attorney fees. Then what it did to the judicial system, and I mean, it added workloads that were unnecessary to the judicial system. So, over those years, that would add up to millions of dollars. But the way I look at it is it cost us a lot of money, but in the end, by doing what's right and fighting something that was incorrect, it saved us hundreds of millions over the years.
Oh, I agree. I think that's pretty clear from what's happened in this case. These four cases or five cases that we've highlighted, they all kind of look at the same issues. One of them is the issue of abstention, and I know that's an issue that you raised, saying that the federal court should have abstained. And then the second issue is whether what y'all did, the changes you made to the bail system after the litigation was filed, whether that made the litigation moot. And then the substantive issues was whether the system y'all had in place violated procedural due process. And these cases have kind of handled these issues differently. And in y'all's case, the court ruled no abstention for you. No, the issue's not moot because of the changes you made, but then ruled, and I think this was the crucial ruling at the appellate level, was that the standard of review was rational basis, the lowest standard of review, which the government always wins on. And before that, like in O'Donnell, they were applying strict scrutiny, and we've been refighting that issue ever since. So, I mean, your attorneys had to see this as a complete victory.
They did, and Jamie and Randy, again, they did an absolute great job with it. But the biggest thing, and I try to humanize things and talk about what we deal with. I just hit August. I had 24 years in law enforcement. I got hired in 1999 with the sheriff's office, and this was my point, even to the Southern Poverty Law Center, even when testifying. I know the mamas and daddies here. I know the
Mhm.
citizens. Even though we have a jail that's over 400 inmates, I still get calls from mamas and daddies and grandparents and that need help, or we don't live in a system that we don't know our people, whether they're in jail, out of jail, we know them. And the point that I made to it is the Southern Poverty Law Center, if they would put their efforts towards helping people,
Mhm.
I think they could do a lot better. I mean, they don't even. I remember talking to Hester. He talked to the group one time and never saw them again. Well,
Yeah.
how can you represent somebody and you never talk to them anymore? And we have a system. Again, I can't speak to every system, but we live in a system that we want to do right by everyone and help everyone. I mean, that's always been our goal, is to take
Mhm.
care of our citizens, even the ones that make mistakes.
Well, I spoke to the lead plaintiff's attorney in the civil core, Alex. I can't pronounce his last name, but
Mhm.
in the Harris County litigation, I spoke to him and I said, "You don't even know the damage that you're doing to the criminal justice system. And I said,
Yeah.
long after you're gone, long after you've taken whatever, done all your little dog and pony show, taken your victory lap and gone, law enforcement, the courts, the bail industry will be around to clean up the mess that you've created. And I said, the fact that you don't even realize what you've done tells me that this isn't about helping people.
No, and I'll tell you a story. So there was a family, and I knew the family, and of course our staff knew the family, and they come in and they had a son that, I mean, he's been arrested, he's been in jail multiple times over the years, and in a year span, he was arrested for 9 felonies.
Mm,
He ended up going and getting in a fight, doing something he shouldn't have been done, and he died. Well, during that time, we have been begging the courts and just trying to do everything we could to keep him in jail. And that was the point that when I sat down and met with the mom and daddy, that they knew if he could have been in jail, their son would probably still be alive today.
sure.
Now, did that prevent him from making mistakes and making bad decisions? No, but they knew. They said, you typically, after he got in trouble once, twice, these things would happen, and he would be with us for a while. And that way they could get him into treatment, help, whatever it needed. But with the way the system was created, it just never stopped for him. He would get one felony, one felony, one felony, one
Mhm.
felony, and it just added up till he ended up losing his life.
One of the things that I say about the criminal justice system is, we put the amount of pressure we think is needed to hopefully turn the defendant around and be productive. That's
Sure.
different for every defendant. And as you get arrested more times, then you need more pressure. And the
Mhm.
problem with these types of reforms, we can't do that. We're required to apply the same low level of pressure no matter how many times you've been arrested. And after you've been arrested multiple times, that's not going to be enough. They're going to see that as a green light to commit more crime.
And that's essentially what criminals did here. I mean, it was a joke to them. They would laugh and say, I know you got me for breaking into this house. I know
Mhm.
you arrested me for burglary, but I'm going to be right back out. And it did not deter them from doing that.
I want to close out this part because a petition for cert was filed at the United States Supreme Court by plaintiff Hester, who we've mentioned several times, and it was against the Sheriff Matt Gentry. And the argument that they were making is substantive due process. We should declare in our country that bail is private surety bail is substantively unconstitutional. And that seemed like that was the first time that argument had been made in the case. And I think that was your response, or your attorney's response is, whoa. This hasn't been an issue in this case. Why is it suddenly an issue?
Yeah, that was, it was interesting to me. Now, never facing a lawsuit like this, it was interesting to me that they tried to change tactics after they lost with the 11th Circuit. Then they're going to the U.S. Supreme Court. They're trying to change tactics, which, from my understanding, they can't do. You got to stay on point to your original reason for the lawsuit.
Well, I think they originally filed all these lawsuits across the country hoping to create a conflict in the Court of Appeals, which is one of the reasons why you could go to the U.S. Supreme Court and ask them to address the case. And so I think they were hoping, that that Trump had not been president and a couple of other people had been appointed to the Supreme Court, and they would have had a chance at that type of ruling that private surety bail in the United States is unconstitutional. But that's not what happened. But it looked like they saw that as their only opportunity to make that argument, and they made it. And you gave a great response, and then the Supreme Court denied the petition for cert. And so I want to say congratulations for staying the course. Congratulations for spending the money. Congratulations for showing counties what they can do when faced with this impossible litigation.
Well, I appreciate it. That means a lot. It's we've had a lot of support. Our citizens here have been absolutely outstanding. I mean, they take care of us, and they support law enforcement in Coleman. They've always taken care of us, and just doing, if you just do what's right. I've said it. Best saying I've ever heard is, if you do what's right, you fear no one. And we want to do what's right, and that's the way we've always been.
How long did it take for things to start settling down. So the case is reversed. Y'all can go back and do the right thing. You can go back and follow bail like y'all under the new order. How long did it take to settle things down?
It actually took a while, and you probably think this is kind of funny, but so there's always turnover with young detention deputies. We hire detention deputies, get them started in the jail. So a lot of them's very young. Well, because this litigation had been going on for so many years, about 5 years, the vast majority, probably 80% of my employees in our detention center didn't even know what bond was because they had
Mhm.
never witnessed somebody having to make bond. And so they just thought that was just normal that everybody signs their own bond and leaves. So it took us a lot of time and training to go back to show them what the legal route is, well, with regards to bail and bond.
Do you feel like defendants have changed uh, their mindset that, hey, they have a green light to commit more crime in Coleman County?
They have. They've changed it. It took probably a good 6 months,
Mhm.
4 to 6 months for them to really realize, hey, we're not going to get out like we did before. And it just, I always go the the word of mouth network within the crime element.
Mhm.
Soon as they started getting arrested for felonies, and they were being held and had to make bond and had to do the correct course, then they started realizing, hey, this ain't as simple as it was. And then which we have a new district attorney now, and once all that started happening, and they started filing immediate uh, bail revocations and stuff like that, where before it didn't happen because they were just going to sign their own bond and leave.
Sure.
Now when you get out and you catch new crimes while you're on bail, they're revoking you and bringing you back to jail, even after you bond out on these revocations.
Well, I look at your experiences and I compare that to Harris County, which was living under preliminary injunction. Then they entered into a settlement, which essentially caught up, is the preliminary injunction. Since all that, we now have the Daves case, which not only reversed O'Donnell, which now has said O'Donnell should have never been filed. But the political situation is nobody will approach the court to vacate its consent decree. And I think part of the reality is they've spent $100 million to implement it, and where they only spent $8 million defending the old system. And so maybe the politics makes it very difficult. But I think the lesson that you can teach, or that you give, or you can show Harris County, is there is light at the end of the tunnel. If you can get out from under this system where the Fifth Circuit has said you should have never have been filed against you, there is light. It may take a little time.
And that's the biggest thing is don't look at what's going to happen tomorrow.
Mhm.
Look at what's going to happen 10 years down the road, 15 years down the road. That's what we were looking at is, necessarily, I mean, it could affect me, and we knew it would, but I worried about what is my children going to face out. I've told you my boys are 15 and 13, or about to be 13 now. Well, if we fail, what will they face when they're 20, 25, 30? What will my grandkids face? And that's really the thing I think about.
Well, I think that's a great point. I mean, if you can't have public safety, then I mean, that's not sustainable. You will revert back to vigilante justice because people
Mhm.
will right wrongs. And I used to say, or I heard this old saying, that really our criminal laws are protect the criminals more than they are to protect the public. And if we're not going to enforce the criminal laws, the public will get justice one way or the other. And we don't want that.
No, I mean, and Alabama is not any different than Texas. I mean, we have good, God fearing citizens that love each other, that want to help each other. But they also, if you're going to break into my house and you're going to come in to hurt me and my family, they're not going to put up with it. And the end result for the bad guys wouldn't be good. I mean, pretty much every citizen in Coleman's armed. I mean, we all,
Yeah.
we all hunt and do, and that's what you would see. That's because if you break into our house and you come in to do something, then they're going to take action.
Well, and I think, the law on this is kind of settling down a little bit. And I thought, one of the points I want to make to you is, your attorney general's attorneys did a really great job. They looked at the case law and saw other examples of states changing their bail law in the middle of the litigation, and that brought the issue of mootness. So I think that's what they did was a great idea, but not only the idea of it, but the analysis of what to do. Because at the time y'all were looking at that, what was being spread across the country of what you should do to prevent litigation was completely different than that. So kudos for that as well. But now you still have the same three issues. Mootness, days was just thrown out for being moot because the legislature amended their bail statutes during the litigation. But also on your abstention argument that you lost on, the Fifth Circuit just ruled, especially I think it applies to you because your judges have absolute immunity. You're kind of one step removed. So why are you a proper party in this litigation? And they're like, no, you should abstain. And if the people assigning bail can't be sued, then you shouldn't be sued either. And I think that's a new ruling. And, that's pending at the United States Supreme Court on the issue of whether they should grant the petition for cert on the issue of abstention. I think that gives the Supreme Court the ability to try to get rid of this litigation nationwide. And so, but I still think that they'll probably deny cert, but that would give them that ability. And then finally, on your issue of on the merits, the standard review that applies is so important. If it's heightened scrutiny, which is what Don will apply, so the plaintiffs won. But if it's a rational basis, like it was applied by the Court of Appeals in your case, you won. And that's really been the fight now. Do we abstain or on a procedural issue? Do we dismiss on a mootness issue? Or do we go to the merits and apply a rational basis? And even if we do that, I mean, the government always wins on those. So it's kind of interesting to see that this litigation is still going forward. And I would argue, this same firm's filing it. They're raising substantial sums of money from a lot of donors. And, I mean, I don't know if you've ever been asked that, but if you had the opportunity to say something to these people who are funding this litigation, what would you say to them?
Well, you brought up a good point, and that's something that my attorneys and because I asked that same question. I was like, well, why are we seeing, even I'll just use my case. Why would, once we won in the 11th Circuit, why would they challenge it to the U.S. Supreme Court? And the reason is because they get more money from their donors.
Yeah.
It's about raising money, not about
that's right.
justice or doing what's right. It's about raising money. And the best way you do it is you act like you're fighting the good fight. And my response was, well, why don't they use that money to the good of the people that they say they're representing? Why not use that money to establish programs for those people to get help?
One of the lessons I learned as being a young attorney is, in law school, we learned this new language, legal terms, legalese. And I discovered even the dumbest attorney can really sound smart. And so when you're talking to a room full of donors that just have a lot of money, you can sound really smart. And you're going to go in there and you're going to say, we're going to change bail across the country. And I would say, how many tens of millions of dollars have they now spent? And for the counties that want to fight, we've really gone full circle and they've lost without penalty. They've really been benefited from it. It's terrible, to see the damage that we're doing, not only to counties, but to individuals' lives. Look at Portland, where we decriminalized heavy drugs and we have a record number of people committing overdoses. I mean, we can't say suicide, but they're overdosing every month. We're giving up on people.
Well, I think the biggest thing that what you and I realize, but they don't, is they're not talking to the mamas and daddies of the children that have died. I cannot tell you how many times I've sat down with mamas and daddies or go to a house and talk to a mom and daddy that has lost their child through an overdose or even, something bad, where you see people that file these litigations, people that do these things, they don't have a reality concept of what our citizens face. They can sit up in a courtroom and say all of these things, but they've never walked through that jail. They've never walked in the community talking to mamas and daddies and grandparents and people that face stuff every day. And I think if they would get down and be humanize what they do, I think they would see a different light than what they see now.
Well, I want to thank you so much for visiting with me today and talking me or telling me about the approach y'all took in Schultz versus Alabama. You're really showing there's an alternative. You do not have to give up to these people. You don't have to give them what they want. Like you said, just do what you think is right, and it'll all work out in the end. So thank you so much for sharing with us.
Oh, yes, sir.
Thank you for listening, and come back for the next episode of The Bell Post.